Hello and welcome to the program. I'm Shola Shoyeli. Just like always, Nigeria joined the rest of the world this year to mark the International Day of the Girl Child, celebrated every October 11. This year, issues of access to the digital space, security, and the provision of basic amenities to help the girl child fulfill her potential continue to resonate. My guest, Mrs. Fumi Falana, is all too familiar with these issues. Mrs. Falana is one of the country's leading women rights activists. She currently serves as the National Director of the Women Empowerment and Legal Aid, a non-governmental organization which defends the rights of women and children. She's very passionate about issues of the girl child, and in this interview she talks about the plight of the girl child and the need to continue to use the courts to challenge norms, traditions, religious beliefs, and even laws which negatively affect this vulnerable group of people.
Not much has been done as to the rights of the girl child in Nigeria. And I want to begin from home. Now, in the family, the girl child is seen as inferior to her brother. Talking about access to education, in some parts of the country, even as of today, the girl child is expected to stay at home or to go learn a trade while the brother goes to school. And I'm sure you know this will eventually create a very wide gap between the education of women and men as they grow up. Then again, even a man and a woman in the house expect that when a woman gives birth to a girl, usually in this part of the world where we say, congratulations, you have a child. Say, oh, a boy or a girl? They will say, a girl. Say, oh, it's a boy. Oh, so that's, again, from the cradle, you already send the signal of unwanted, unrespected, inferior to the girl who is just coming to the world. And this she grows up with, and the girl is asked, go to the kitchen and cook, your brother go and play or go and watch television, go and play football. Why the girl? It is the duty of the girl to take care of the home, but it's not that of the man. So from there, she begins to develop this, the mentality of inferiority and sees herself as being inferior. Then again, when they begin to go to school, in school, the girl child is also seen as not as good as the boy. And so all these go on to affect the girl child psychologically and emotionally. Now, the essence of the International Day of the Girl Child is to create the awareness of the nations all over the world to the plight of the girl child. And of course, the plights include inequality in access to education, child marriage, child trafficking, domestic violence, which is very, very rampant, rape, indecent assault, child prostitution, hawking, and so many other things. Then again, we talk about violence in the society. The girl child is at the risk of rape. On the pages of newspaper, you hear stories of a child being raped, an underage being molested, even by sometimes by stepfathers, men in the home, even people quoted unquote uncles. And so these are things that again we need to also look at. The law of rape in Nigeria, the law guiding the prosecution of rape in Nigeria, really, well, of course we do have the laws, but the procedure is so cumbersome that it has become increasingly difficult to get people prosecuted and of course convicted because of the so many technicalities involved. Of course, one of such that we have tried to campaign against and ask that should be expunged from the procedure is the fact that the rape girl, the victim, evidence must be corroborated. And you ask me, is it possible for somebody who wants to rape to call a third party to come and witness when it is not a dinner party that you invite people to come and witness? So most times we do not get people to corroborate the evidence of the victim. And again, from the time the girl is becomes a victim, you need to also keep some things in place like the underpants and other things. These, of course, are usually also defeated. And so we don't get this done.
What would you say is the way around that?
The way around that is to reduce the technicalities associated with the procedures in the prosecution of rape cases.
Is it by tinkering with the laws?
Yes, not just the procedure, yeah, the procedural laws, which also are developed over the years, can also be reformed. And this, we have been campaigning for this. Under the laws, we can reform this procedure. For example, it was part of the procedure of the law, where the common law procedure, that a married woman could not be raped. But the law has since gone beyond this, because now I'm sure you know that we have marital rape. A husband can be jailed for raping the wife. Of course, if the wife does not give her consent and you go against the consent, well, you can be jailed for that. But in those days, it will be said that in marriage, your rights, all your rights have been submitted to your husband. But this, again, through judicial activism, which we are also doing now to reduce the technicalities in prosecuting the cases of rape, well, through judicial activism, those things also went off. And so now today we can validly say a man can be guilty of marital rape. So we are also looking forward to one day that we will be able to say, okay, this technicalities associated with prosecution of cases of rape have also been done away with. Again, we also want to appeal to many states. There is the Child Rights Act, which is the national law, but because the issues of children and women is under the exclusive jurisdiction. So it has to be by the states. The states must be the ones who make laws that govern these issues. And therefore, we are saying that for the Child Rights Act, they must be domesticated before they can validly be used in these states. And there are, out of the 36 states, as of today, we have only 22 that have domesticated the Child Rights Act.
Let's talk about the Child Rights Act. We've been on this issue of domesticating the act for a long time now. What do you think that we should be doing differently?
I think there are people in the states that can also go to court and compel them. This, again, is what we call judicial activism. I'm sure you remember there was a case, we went to court to challenge the regulation 124 of the Police Act. And the court went ahead to strike it down. And since then, it has become a law. You know, the beauty of legal profession is that the development of the law can be done through judicial activism. And this is what we call judicial precedent. When a matter is taken to court and a decision is obtained on a particular issue, if it is a decision of a superior court, it becomes the position of the law on that issue. Now, for example, the case we took to court on regulation 124, because it was a decision of a superior court, it has since, the position now has since become the position of the law as of today.
What does regulation 124?
Regulation 124 states that a female police officer who desires to get married must take the permission of her commander before she can get married within the first 3 years. But that, again, is not applicable to her male counterpart. So we took it to court based on the right to freedom from discrimination. Section 42, which says that nobody shall be discriminated against in the society, in the place of work, even at home, anywhere in Nigeria, based on sex. And the courts held that, yes, that is a fact. This law is, of course, very discriminatory against women, and so it should be expunged from the law. And so since then, it has ceased to become part of the law. And there are so many other laws that often patently discriminate against women. Now, you will ask me, what happens to a man that impregnates a woman within the first 3 years? Nothing happens. So all these are things that also show that the rights of women, of course, vis-a-vis the rights of the girl child, need also to get more attention and to be more respected. Yes, and I was talking about child trafficking. Yes, this again is one of the plights of the girl child. You will notice that in homes, and I want to bring this to the attention of young mothers who are nursing mothers, who are working mothers, who take house girls, domestic servants. It is against the law to take any girl that is below 18. It is an act of slavery and torture to take any girl that is below 18 to be a house help in your home or a domestic servant, because that age between the age of 6 and 18 is a school age. They should be in school. And so if your own children are in school and you bring a girl to be a servant, that's slavery. It is against the law. And so they can be prosecuted for that. As a matter of fact, the Child Rights Act of Nigeria and the Child Rights Law of Lagos State specifically prohibits that whoever is found is guilty of an offense and can be liable to 3 years imprisonment. And it is the right of the child in Lagos State under the Child Rights Law to freedom of education at least to JSS level. And so any child that is found on the street during school hours should be taken away from the street and registered in school. Especially the girl child. Now that we are celebrating the International Day of the Girl Child, we must also bring our attention to the plight of the girl child, especially their right to equal access to educational opportunities.
You've said a lot to us about the discrimination that the girl child faces, but what can be done about the religious and cultural norms that enable this?
It is the position of the law that any custom or religious belief that is inconsistent with the provision of the Constitution is null and void. And so all we need to do is to begin to bring to the attention of the people and campaign against these discriminatory practices that are discriminatory under the Constitution, as well as against the rights of the girl children. There should be more campaign and enlightenment. I want you to know that most of these parents do this out of sheer ignorance, because there is no religion that prohibits education. I was telling somebody this morning, no religion says that the girl is inferior to the boy. The boy child is sent to school, the girl child is asked to go and marry. There is nothing in any religion that says the girl child should not go to school. So we therefore should begin to enlighten them and campaign against these beliefs. And of course, like I said, one of the ways we can campaign against these beliefs is to take these practices to court. Go and test them in court. You have a right of a day in court. Go and test them in court. The beauty of our law is that our law, the development of the law can be gotten through judicial precedent. When you get to court, if a decision is made, it becomes the position of the law. There is a practice in the eastern part that was taken to court. Majeku and Ojeku. The practice was that a man that does not have a boy, a man that does not have a male child, if he desires a male child, can allow one of her female children to remain in her home, in his home, and begin to procreate for him. If he will now go out, get pregnant, it will be impregnated by another man, but bring the pregnancy home, and the baby will now be answering the name of the father. In other words, the baby will be that of the father, not of the biological father. And we went to court. The court said, no, it is repugnant to natural justice, and it is inconsistent with Section 42 of the Constitution, and so it is null and void. And so that practice cannot stand in the face of the law and should be expunged. So these are areas we should look at and see how we can reform our society through judicial activism, how we can reform our beliefs. Because I want to let you know that tradition and cultural practices are also dynamic. What you believe must move with time. And so as we progress, as we begin to also get educated and awareness of our people is going up, we also must begin to change our beliefs. And that is why we need a lot of campaign and a lot of activism to change the beliefs and the practices of parents, of the society, against the girl child in the society.